Hi everyone, welcome to Immigration Talk Show. I'm your host Rajni, and before I move ahead, let me read out a very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration Talk Show. I am Rajni, your host, and today we are diving into a crucial topic: DHS targets visa fraud, what F-1 and H-1Bs need to know. Well, with new DHS policies cracking down on visa fraud, individuals with findings of fraud may now face deportation. Yes, this is especially alarming for those unknowingly caught up in fraudulent OPT employers. To break it all down, we have immigration litigation attorney Jonathan Wasden with us. John has years of experience fighting immigration cases, and today he's going to help us understand what these changes mean for visa holders and how to protect your immigration status. So, without any further ado, let me welcome John again to Immigration Talk Show. John, welcome back.
Thank you. Thanks for having me, Rajni.
Thank you so much for being here. And this is a very important topic, John, and very timely one. So, before I move ahead with my questions and before I begin with my questions, John, if you can please give the audiences a brief about this new policy of DHS.
Sure. So the NTA, or notice to appear process, initiates the deportation or removal process. And that's what DHS's Immigration and Customs Enforcement, ICE, needs in order to, arrest, detain, and eventually remove or deport somebody. The policy over the notice to appear process has been in place for the previous policy, I should say, has been in place for a while, and it just prioritizes who the current administration wants to see removable and removed. And the Trump administration just came out with a new, updated, changed version of their policy and their priorities and what they're looking to attack and remove. And embedded in there on page 4, in paragraph 4 of page 4, is something that I think is very telling about what USCIS has been doing for a long time, and then also telling as to what the Trump administration wants to do. And that is really going after these secret fraud findings that are entered by DHS that you have no notice or hanging over your head until you're in a situation where it's very hard to challenge.
Wow. But John, when you say that the current administration want to see removed or want to remove, what do you mean by that? I mean, who they want to remove?
So, there always has been a big push for people who are, unlawfully present, who have entered without a visa or have overstayed visas for a certain period of time. What are called criminal aliens, people that have certain qualifying convictions. They've always wanted to remove those people. And so that's not terribly earth-shattering or nothing about that is particularly new. And what is new, though, is targeting people that have unknown fraud findings against them and including them. All of those other people that we just talked about, there's very clear violations of law. They had an expiration date on their I-94. They overstayed that for more than 180 days. And, they're here unlawfully or accruing unlawful presence. Or they were given some other type of notice that they had done something wrong, or they were on notice that they had done something wrong. What's unique about the current changes targeting those with undisclosed fraud findings is that you don't know that you've done anything wrong. It's just some USCIS employee subjectively looking at your record thinks you've done something wrong. And you've never had any notice that that's going on, and you've never had an opportunity to rebut that allegation. And they're taking those very subjective findings by some random USCIS employee and using those as a basis to put people in deportation proceedings.
Wow. So does it mean that whether you are legal or illegal, you have the equal chances of facing a deportation now because you don't know?
So I guess it just creates a lot of certainty about who is legal and who is not, because you could have a valid visa and you could think you've done everything correctly,
Yeah.
but somewhere in the back of USCIS, they've gone through the process of identifying, you as somebody who is inadmissible and therefore eligible for removal. What's the real problem with that is they're making that decision here in the U.S. based on facts that occurred here in the U.S. Under any recognizable process of law,
Mhm.
they would have to give you notice and an opportunity to respond, and then give you written notice of their decision after they've evaluated your response.
Mhm.
That's a very, very, very basic requirement in American law for these administrative proceedings. And they're just completely going around that and just ignoring what the law says that they have a clear obligation to do.
No, so they are just trying to find a loophole, and as soon as they are able to get it, they are trying to implement it as in the name of policy,
So,
is it?
yeah, so a loophole would imply that there is, a gap in the law, but
Mm.
there's very clearly no gap in the law here for the government to point to.
Mhm.
The law is incredibly clear, it's explicit that when they're going to take an adverse decision or adverse action against a non-immigrant, they have to inform them of the intended action, and they have
Mhm.
to inform them of the evidence or information that they intend to rely upon, and then they have to give them a written decision letter. And they're not doing any of that. And there's very specific reasons why they're not doing that, because they want to put people in a position where their access to the courts is minimized so that they can avoid judicial review of what they're doing. If they think in their mind, if they wait until you're out of the country, the consulate, where you have limited access to the courts, or at the port of entry where you have limited access to the courts, or in the removal proceeding process, that their law breaking will never come to light. And that's their intent.
Okay, okay. But John, also with this, I would also like to know that in under this policy, what actions are considered to be a visa fraud?
So they don't really get into that, but what we have seen just in practice is, these people who were on OPT here in the US, especially during COVID, it seemed to start during COVID.
Mhm.
There were scam companies that were going out on LinkedIn and other social media networks, actively recruiting recent grads who were from China and India predominantly. And they would go through this sham interview process that looked really legitimate. Some of the companies were actually at one time legitimate companies and
Mhm.
just kind of went off the rails and started scamming people. So that those companies actually had, prior projects and prior contracts that they could point to in the recruitment process. So by every measure, these looked like legitimate companies. The recruitment process looked legitimate. Then they would hire you, you would get your OPT, you'd list the company on your I-20, and then they would spring on you, in order to place you at a project like we promised, you need some additional training. And so you need to pay us for that training, and we'll give you the training. And that is the basic scam. And then once you pay them the money, sometimes they would have training, usually be kind of dubious quality, and then you'd never hear from them. And that was the basic setup of the scam. So you would realize the scam and then move on and find a new employer. That is what USCIS has been saying it constitutes immigration fraud, not on the company, but on the individual student. And that's one of the things that we've been fighting in court for quite some time. And the government so far has been very reluctant to defend.
Wow, so but I'm sure all these peoples, because a lot of them when they apply for visas or when they want to work abroad, they don't. I can call it lack of information, because sometimes they don't know that they just want to get in, right? They just want to take a job or get a job. They because of the lack of information, they don't know that this is a rule under which you're not allowed to pay or you cannot pay. So, but then, John, is it a rule? I mean, people are people aware about this?
So there are certain rules prohibiting payment to employers. Usually that's in the H-1B context where it's explicitly clear you can't pay for the attorney fees and you can't pay for any of the fees associated with the petition or the LCA preparation. that this is a little different. There's really nothing on point saying that you can't pay somebody for training, you can't pay for marketing or what have you. The, you know, what USCIS tries to do is they try to, when they do site visits or at the port of entry with CBP, is they try and force you to say that you didn't pay for the training, you paid for an offer letter. And if you paid for the offer letter, then boom, they say you're guilty of fraud. But they assume everybody paid for an offer letter. And they ignore the fact that, the representation that was made to them was you're paying for training so that we can then market you for contracts that, the company would make money on, presumably. And so, what USCIS considers to be fraud doesn't really match up with the definition of fraud that's in the law.
Okay, okay. And before I take up my next question, that a lot of people have joined us, so let me quickly say hi to all of them. I think Ashwin has also dropped a comment. So hi Ashwin, we'll be taking a comment in a bit. And guys, if you also want to ask your questions to John regarding this topic, you can also give us a call on the number 425-436-6335. And don't forget to put the access code 988888. Yes, you can join us on a call and ask your questions from John. And if you're liking this webinar, if you're liking this show, make sure that you like it, share it, and also subscribe to Immigration Talk Show. And yes, coming back to the topic, John, then also, I would also like to understand that how does DHS investigate or do their research and find out that this maybe this student or this person who holds an H-1B visa is committing a fraud?
So, as near as we can tell, because they haven't really disclosed any of this information to us, and maybe that's the better place to start. DHS runs E-Verify, which is the process and the database that students rely on to determine whether or not the company that they're accepting a job offer from is legitimate. And they've been certified by DHS as being so. All of these companies that we're talking about were E-certified. So you get the job offer, the first thing the student does, they go check the system. Yes, they're legit. And then they proceed on with the interview process. The DHS has not disclosed at any time publicly what companies they suspect of committing fraud in this way. So you would think that the government would be looking out to protect people and would alert the public to these companies are suspect and we've blacklisted them. But they're not doing that. And they're not doing that because, such a blanket blacklist would be illegal if they were admit that they were doing it. So that's the first problem that we've got here is just the very nature of the blacklist is something that they realize that they're not able to do, and so they're not publicizing it to the world. Instead of taking a proactive approach and helping people, they're intentionally letting people step into a trap and then penalizing the victim of the trap instead of the person that set the trap.
Okay. Okay, so that basically they're setting a trap and wanting people to, get in.
Yeah.
Okay. John, with this also, I would like to know that how does it also affect, people who are currently participating in OPT and those holding H-1B visas, or maybe someone who is currently seeking a re-entry into the US?
So if they have one of these blacklisted companies on their I-20, then they should be concerned. And you know who these people are because you have friends that have tried to go get a visa stamped and have been told, no, sorry, you worked for a blacklisted company. USCIS made you inadmissible for fraud. And so if you have people that or some of these companies were so large that it's common knowledge who they were now, then you can reasonably expect that at some point in the future, it's going to catch up with you. There have been people that have made it in and out of the country multiple times and have gotten stamped multiple times that have worked for these companies. But inevitably, at some point, all of them, even with multiple re-entries, have gotten hit. And they find out about it at the port of entry or when they go for stamping a later date. So it's going to catch up with them, whether or not they have a new visa category or an H-1B or an F-1 with a new employer, it will follow.
Okay, then what steps should they take? I mean, these OPT participants and H-1B holders, to ensure the compliance with the new policies, and and also especially when they are traveling, they are planning to internationally travel.
So definitely, yeah, if they have impending travel, they should talk with a lawyer about how to handle CBP, what CBP is going to say to them, and what they should say, based on the facts of their particular case. CBP is very aggressive these days, much more so during Trump than they were, under Biden. And we hear stories every day from clients that after the fact, they weren't clients before, but they go through CBP. CBP puts them in secondary, grills them, terrifies them, and threatens them with jail time, which is absolutely absurd. They can't do that. They can't put you in jail for working for a blacklisted employer. They know that, but you don't. And so they get you to sign some incriminating confession that they wrote, and you haven't typically had a chance to review. And then they use that to support their decision for expedited removal. So to protect yourself from that, there's two things you can do. Talk with an attorney, figure out what your actual rights are at the port of entry, and then have a G28 form signed with that attorney so that if you're in that situation, you can request CBP contact your attorney and allow your attorney to get involved. They don't have to let you do that, but they won't do it 100% if you don't have the G28. So that's an important first step to take.
Okay. Thank you for answering the question, John. A lot of people have joined us. RK is here, Santosh is here, and also Ronak is also here from LinkedIn. Guys, I'm quickly going to take your questions. But before I do that, John, I would like to come back to you and ask that does it affect F1 students the same way it is affecting the H-1B holders? Or, I mean, they will have to take different steps?
So if you, for this current situation that we're talking about, the OPT scams where they scam students, that is applying to people regardless of their current or laterally acquired visa status, because we're dealing with what's called admissibility. So anytime there's an extension of status, a change of status, or a visa stamp, or an admission at the port of entry, your admissibility is being reviewed. And if at any point during your immigration history, somebody has marked you and determined that you committed immigration fraud, that should prohibit you from ever getting any other immigration benefits in the future. And so it doesn't matter that you switch back and forth to different categories. If that inadmissibility flag is on there and has not been removed, it's going to be a problem for you at some point.
Okay, okay. And with this also, John, I mean, how can these F1 students verify the legitimacy, the legitimacy of their potential employers? I mean, whether the job and the employer is someone that they should be thinking of working.
Yeah, well, they unfortunately can't rely on the government to vet people and disclose who are problem companies. So it just really requires a lot of self-advocacy. You've got to go out there and ask for references of, other employees that have worked for them to verify that they're actually doing what they say they'll do, that they're actually placing you on a project, that, everything is working the way that they're promising in the interview. And then just in utter abundance of caution, anytime an employer is asking you for money, run. Don't do it. Just it's not worth it. It will only be seen as something that's bad for you in the future if it comes out. Even if it's just for marketing, even if it's just for training, I would say just protect yourself and don't do it.
Okay, that's a great advice. Thank you for that, John. Now, I think I should take the viewer's question. And guys, I would also like to tell you that very soon we are going to have a detailed webinar on this topic where John is going to take each and everything about this topic and going to inform you everything in detail. So you are allowed to join that webinar, and the details are going to be soon out when it is happening. But then I am informing you about it. So stay tuned with Immigration Talk Show. We are going to post about it. Okay. Let me quickly take maybe Ronak's question first. Ronak says if somebody has a fraud company on their service, Do people need to reach out to Jonathan now, or do they have to wait? John, what do you have to say?
So we have a lot of people that have got these companies listed on their I-20 and have never been given notice that there's a problem yet. And that's very typical for people who have stayed in the US that have changed status to H-1B or continue on F-1 status. The reason why that's so typical is that USCIS is intentionally not giving you notice, and they're waiting for you to leave the country. Because if they gave you notice and a chance to respond and made a decision, you could very easily challenge that in court. So what they're doing is they're waiting for you to leave the country and wait for the consulate or the port of entry to tell you, because that becomes much harder to challenge if the consulate denies your visa or the port of entry removes you. So, and in most cases that we do, we have a mix of people that have never left the country, that have never been informed of a problem, and people that have been to the consulate and put in 221G and been told that USCIS flagged them for fraud based on these OPT companies. So, if you worked for one of these companies and they've been blacklisted and people have had problems just by the mere association with them, then, reach out to us and we can discuss it with you, because it's probably better to be proactive and take this before you get notice than be reactive. It'll save you a lot more time and a lot more hassle.
Absolutely. And Ronak, I don't think so. In things like these, you should delay them. You should directly get in touch with John and his team. The details are mentioned, on the screen. You can give him a call on the number 844-592-7336. 844-592-7336. You can also email him. His email ID is support@wasden.law. And you can also visit his website, which is www.wasden.law. So yes, get in touch with John and his team as soon as possible, so that they can help you with your concern and with your immigration related case. And John, before I take Karan's question, Karan has also posted a question on LinkedIn. Before I do that, I would like to also talk about the case that you recently won. If you can please, inform. I already know, but also our viewers about it.
Yeah, in a similar vein, USCIS was penalizing students for their employer's multiple registration violations for the H-1B lottery. So we sued on behalf of a plaintiff who was a student who was changing status to H-1B, who'd been selected in the lottery, and he had been working for a while, and then they revoked the cap number and they revoked the petition's approval. And so we went to court saying you can't take away his cap number because he's done nothing wrong. The law only allows you to revoke a cap number for fraud when it's the individual foreign national or non-immigrant who's committed the fraud. The government tried to get the court to dismiss the case, saying that the court didn't have jurisdiction or that wasn't a valid claim. And the court told the government, no, this is a valid claim, that we do have jurisdiction, and now the government has to defend the merits of their decision, which is going to be very tough for them to do, in my opinion, because the law, again, here is pretty clear that in order to take somebody's cap number and penalize them by revoking the cap number, they have to have been guilty of doing something that made them inadmissible.
Okay. So congratulations on that win, John. I have a lot of questions about the case, which I'm going to ask. But maybe before that, let me take Karan's question, and then we can, after some viewers' question, maybe we can talk about the case a little bit. So Karan here wants to know, when should someone clear their record? Is there a specific timeline?
So there's a statute of limitations of 6 years that applies to when you've gotten formal notice of something. The problem is, if you wait until you get formal notice, you might be in a situation where you don't have access to the courts to clear it. So again, if you're at the port of entry and you get removed, if the port of entry says that they're basing that decision on their own discretion or their own analysis of this situation, there's not much you're going to be able to do. Same with the consulate. So the only time that you'll be able to sue once you get notice from the consulate or the port of entry is when they openly disclose that it was USCIS. And to avoid being in the uncertainty of that situation, it's probably best to do it earlier and before there's a problem and before you're in a situation that's much harder to overcome.
Right. So, Karan, also, I would like to suggest you to get in touch with John and his team. They are going to help you with your case. If you have any concern or anything else that you would like to know about, they are there to help you out. So, make sure that you get in touch with him and his team ASAP, as soon as possible. And the details are again here on screen. You can give him a call on the number 844-592-7336. Send him an email at support@wasden.law, and you can also visit the website wasden.law, www.wasden.law, to know more about his team. Okay, so I think we also have, and also Ronak and Karan, if you have more follow-ups, more questions, please continue posting them in the comment section. Meanwhile, let me quickly take RK's question. RK says, do USCIS allow for applicants to report those scams? Because that would help in the future if candidates don't report it, even if innocent wouldn't. You think USCIS would believe you are in on the scam? There's no full stop, no comma, so I just read it. I hope you understood,
Got
John.
it. So, in theory, that would be definitely the best option to take. I would say if you're considering going that route, then work through an attorney. I would say, you know, frame it in the way that you're reporting a crime. Because if you're reporting a crime, certain protections will apply, and that might help you. However, the problem with dealing with USCIS is when you think logically and you try and come up with a reasonable approach, that's always the wrong approach in their mind because they don't think logically and they don't think reasonably. And so, you think you're trying to do the right thing, but it still could end up, biting you. So I'd say really talk with an attorney and come up with the best strategy if you're inclined to go that route, just to make sure you don't inadvertently say something that's going to be damaging to your future.
Okay, but John, with this also, if you can also tell us that what legal defenses are available to individuals, who receive an NTA based on this alleged visa fraud.
So once you go through the NTA, once you get the NTA and you go through immigration court, it's normally they rely on documents and evidence that has already been vetted through the administrative process that you've already responded to, and you're not shocked by any of these things. This situation is new. It's never happened before that somebody's just been thrown into removal proceedings on a secret fraud finding. And so I don't know that anybody really has the answer for how that's going to play out in immigration court. But at any rate, the government will have the burden of proving that you are inadmissible. And they will have to go through the elements of what constitutes fraud or misrepresentation under the law to show that you committed those things and that was a knowing action on your part. I think for most of these people, that will be incredibly difficult to do for most people in this situation. And they probably will expend a lot of resources, and the government will expend a lot of resources trying to remove people. And I'm not sure that the outcome is as certain as they think it is. But the downside to that whole thing is, are your odds of winning an immigration court good? I think so. But does that mean it's not going to ruin 5 years of your life and cost you a ridiculous amount of money to fight? Yeah, that's likely as well. So, I think if you can avoid going through the immigration court process, that's always the best option.
Okay, okay. Okay, Rag is also here. He says, John, what are the repercussions of TCS and L1A?
In what regard? I like if you have a fraud finding, that the fraud findings are going to apply to any visa category. Doesn't matter what category you're in when they put it on you, it will continue to apply to new categories or new admissions to the US anytime.
So it's going to be the same for everybody.
Yeah.
Okay.
Yeah. There's no way, that's part of the reason why they went through all these biometrics, right?
Mhm.
Your records now are all tied to biometrics so that they can prove that there's one person that this applies to and it's going to apply to them forever. And just because you change status, just because you leave the country for a while, even if you get citizenship in a different country like Canada, those records are still going to be there and still impact you.
Okay. And I think, John, he's asking about what are the repercussions of the TCS L1A episode. I think they were recently caught doing a
Oh,
scam. Yeah.
yeah. So keep in mind there's two different things going on in the approval of any employment-based non-immigrant petition. There's the petition's approval, which gives the employer the right to hire and employ you, make money off of your work. And then there's the status that the individual gets. And the status can only be given to you if you're admissible to the US and you're eligible for the visa category. Like you have the right background or right skills necessary for the visa category. So as long as the individuals have not done anything to jeopardize their status, and as long as there's no evidence of that, in theory, they should be fine for future visas. The problem with that is, USCIS has created so much unpredictability in this situation like this that they inevitably attack the employee for something the employer has done because it's easier for them to do that. And so, that's what creates uncertainty. We just don't have an explicit answer on how they're going to handle this situation, and a lot of it's going to be case by case and what information is in there that the employee has provided that impacts their admissibility.
Okay. Okay. So, Rag, I hope you have got your answer. Thank you so much for your question. If you have more, please continue posting your follow ups. We'll take them in a bit. But, John, I would like to again come to you and also ask you that let's say if somebody receives an NTA, then what is the role of the employer there? Can the employer help the employee in some way? I mean, that's a bizarre question,
Um,
but yeah.
yeah, they can. They can help with getting an attorney for them and giving them emotional support. But you're just going to have to look at all the surrounding facts of each individual case to determine what you should do next.
Okay, okay. And then what should, as soon as, if the individual receives an NTA, then what should the employer do? If, I mean, of course, the employee is going to inform the employer. So what should be the first step of the employer?
So the employer should talk with their immigration counsel immediately and determine what the current status for that individual is and whether or not they can continue to employ them legally in the US. So that's on both the employer's interest and also the employee's interest, because if there's unauthorized employment involved, that makes your situation worse. So it's best to get with an immigration counsel and discuss, okay, what is our situation, what's our status, and what can we do to continue working.
Okay, okay. Thank you for answering the question, John. Rag says, thanks, Rajni and John. Thank you so much, Rag, for your question. And let me take Ashwin's question quickly. Ashwin says, I'm an F-1 student on OPT and I have recently changed employers. I just heard that DHS is cracking down on visa fraud. How do I make sure my employment records are solid if I ever get audited?
So you just want to make sure that, if they're on your I-20, if you didn't have any work that you actually did for them, how you report that is going to be a important distinction. So if they didn't give you any projects to do or any work to do, I wouldn't really list them on your resume as a prior employer because you don't have any experience to point to. Because if you list them on your resume and submit that resume with an H-1B petition, USCIS may see that as immigration fraud because you made yourself look more eligible for the position than you actually were, by misrepresenting how you acquired your specialized body of knowledge. So, you really need to evaluate what was done with each employer and whether or not you should put them on your resume. Now, they will be on your I-20, and there's nothing you can do about that. It's going to be there forever. So if you're questioned about that and they didn't ever give you a project to work on, you just need to explain, I didn't list them as an employer because they never gave me any work. So, what would I say about that on my resume in terms of duties accomplished or things accomplished? So just be very clear why you're not listing them if asked.
Okay, okay. Thank you so much, Ashwin, for your question. I hope you have got your answer. In case you have more, please continue posting follow-ups. Let me quickly take Santosh's question also. He says, I have been working on an H-1B for 2 years. My employer originally filed my petition with one work location, but I was later assigned to a client site. Could that put my status at risk if DHS investigates my case?
A lot of variables there. It would just really depend on where each location is and, if it's in the metropolitan statistical area. So that's something you'd really want to just talk with an immigration lawyer about, just to get all the specifics to get an answer that's accurately tailored for you.
Okay, but John, how do they pick? Because I'm sure there are so many people who are working in the US on different visas, right? So
Mhm.
then, how does DHS picks that this is the case that we are going to investigate, or maybe this is the employee, or this visa is the visa that we will be giving more attention to? How do they pick?
Mhm. So with USCIS, it usually starts with the FDNS site visit process. So they'll do a site visit, and then they'll ask for a whole bunch of information from the employer that they're really not entitled to and they have no business asking for. But a lot of times employers will just blindly give it to them. And then they go through that data and they look for any type of discrepancy with other visas that the employer has. So if they see that somebody's, assigned to a location outside the metropolitan statistical area that's on the LCA, then that will get flagged. So you just have to be very careful of what information, if you're an employer, what information you give to FDNS. And if you're the employee, I would highly encourage you not to talk to FDNS without an attorney there with you or on the phone with you. And preferably don't talk to them and let the attorney do all the talking for you, just to make sure that whatever you're saying doesn't get twisted.
Okay, okay. All right. Thank you so much again, John, for the answer. I think we have got a follow up from Rag and RK. Before that, I would like to take another follow up, which didn't, I don't know why, but it didn't come through. But it is again from Ronak, and he says approximately how much time does it take to clear the record of fraud finding?
So in the cases that we've had so far, it's kind of run the gamut of a certain amount of time. What we do know with accuracy is that once you file the case, the government has 60 days to come back into court and tell the court what they're going to do. If they're going to defend the case or if they're going to settle the case. What we've seen happen in practice, though, is the government has asked for additional time so that they could identify who the plaintiffs are and just make sure they had the right records that they were looking at. They've asked for that additional time, and then they've entered settlement negotiations with us where they said, okay, we'll put in court a document saying that there's no fraud finding if you'll dismiss the case. So we do that, we dismiss the case, and then people have that document that they've been able to take to the consulate and through the port of entry saying that there's no fraud finding. That's come in handy for a lot of them because not everybody's records were magically wiped by USCIS. So when they went to the consulate, even if they'd been before and were told, you have a fraud finding, there's nothing we can do for you, they go back to the consulate, they give them that letter. Or if they get questioned about it at the consulate for the first time, they give them that letter. And so far, that's allowed them to get stamped and re-enter the U.S. So that's the process. It's taken anywhere from those 60 days to 7 months in the more extreme cases.
Okay. Thank you so much, Ronak, for your follow up. If you have more, please continue posting them. I hope you have got your answer. I can see Rak's follow up, so let me take that first. Rak says, does the DHS and USCIS have the access to the IRS, IN, and W 2 data?
So they don't have access to IRS information. The I-9 is something that is not an IRS document. It's a DHS document. And so they have access to that, but usually they do an I-9 audit and they come and take the employer's records and they look at the employer's records that are kept there at the office.
Okay, all right. Rag, I hope you have got your answer. Let me take RK's question. He says, what will happen with individuals' authorization to work while in immigration court due to this NTA for fraud?
So anybody that goes into the immigration court process can apply for an EAD while you're in immigration proceedings. Yeah, how long they take to act on that is an open question, and how long it'll take to get your EAD is an obvious concern. And then it's probably going to be for a limited duration. You'll have to renew that. It's just going to be a never-ending stream of hassles, but it potentially is possible to get an EAD while you're in immigration court proceedings.
Okay. Okay, thank you so much for answering the question, John. Thank you so much, RK, for your question. And I hope you have got your answer. And Ronak says, thank you very much, John and Rajni. Thank you so much, Ronak, for your question. And also, guys, I would like to tell you that very soon we are going to come up with another webinar on this topic, on this DHS's policy with John, where John is going to delve deep into each and everything specific related to this policy. So make sure that you join that webinar. The details are going to be out soon. So for that, you have to subscribe and you have to follow Immigration Talk Show so that you are informed about the upcoming webinar. It's going to be a detailed one, which I don't think so you should miss. So yes, stay tuned and subscribe and follow. Rag is back, and Rag says, do L1 employees also carry a PAF, public access file? What do you have to say, John?
So the public access file is definitely an H-1B policy. I do the litigation in the firm. Justin Rivera does the non-immigrant visa filing. So I'd defer to him on that, but I don't think the L1 is something that has a public access file.
Okay. All right. So Rag, let us know if you have more follow-ups. Thank you so much for your questions, guys. So Priya is also here. I don't think so I've taken her question. So Priya says, I was previously on an F-1 visa at a university that was later flagged for visa fraud. Even though I'm now on an H-1B, could I be affected if DHS starts reviewing past students' records?
We have seen those cases where people are in that situation. I would say get with an immigration lawyer as fast as you can and look at all of your records and see what your exposure is and what risks you're looking at in the future.
Okay. All right. So Priya, I hope you have got your answer. Karan says, thank you, John and Rajni. Thank you, Karan, for your questions, and make sure that you join us on the upcoming webinar with John, where John is going to talk in detail about this policy and about fraud findings. So whatever question yeah, please go ahead, John.
Oh, sorry, Rajni. On that with the webinar, so one of the things that the government has been saying in court and defending themselves in court with is that they do not engage in secret fraud findings. This new policy that they came out with admits that they do, if you look at that paragraph 4 that we mentioned earlier. So we're restructuring the entire way we're doing these cases now and incorporating that into it, because that is really damaging information. And that's something we'll talk about more, the strategy that we've got for the upcoming lawsuit in that webinar.
There you have it. So guys, make sure that you are constantly following Immigration Talk Show so that you know when the next webinar is. We are very soon going to come up with this webinar. So prepare your questions. I mean, if you have any questions, you can ask John in that upcoming webinar. For now, John, I would like to come back to the case that you won. So if you can please tell us, what legal precedents did you put in front of the court for for the H-1B visas those were filed multiple times by the employers?
So the motion to dismiss stage is the first of 2 stages in these types of cases. And the motion to dismiss stage is on really, really nerdy procedural lawyer stuff. And whether or not the employees had standing to sue and challenge an action that was taken based on the employer's conduct. And we just pointed to the body of law that says you can challenge a government action that negatively impacts you, even if it's because of the actions of a third party. They weren't immigration cases, but we made analogies to those other cases. And we also just said, the Administrative Procedure Act is very clear. If you are an interested party, and the only person that's interested in the cap number, as opposed to the petition's approval, is the foreign national. So they're the ones that have been impacted. And if you've been impacted, you can challenge a government agency action that it's negatively affecting you. And those are really not controversial concepts, but the government's been fighting along those lines in each case. So I think we're on a good track for those other cases that are still out there.
Also, John, but then how does this ruling affect, the current and the future H-1B visa holders?
So it'll affect those people that had their H-1Bs revoked because of this multiple registration issue. So when they go to court and they sue on this, there'll be precedent that says, yes, you're legal, you're allowed to sue the government on these facts. And that will streamline their cases and save them some hassle.
Okay. All right. Okay. And also, if you can tell us that what measures can be implemented to ensure, that employers adhere to ethical practices during the H-1B registration process, because I think it is going to start from tomorrow. Tomorrow is the
Yeah.
D-Day. So if you can please.
Well, when they came out with the prior lottery rules, the way that they were doing it based on the pre-registration, everybody knew this was going to be a problem. And immigration lawyers tried to convince USCIS to do it differently and to make it an employee-centric as opposed to, a registration-centric selection. And USCIS refused to change because they didn't have time. They took too long to get this out, and they needed to have it ready for I think it was the 2020 lottery. They've now changed it because of what a debacle this was, once their incompetence came to light. And now it's an employee-centric. So you can have multiple offers, but your name only goes into the lottery once. So I think a lot of the shenanigans have been eliminated just by virtue of that rule change.
Okay. All right. Thank you again for answering the question, John. Before I take up next, I think Rag is here and says, is it prudent to hire an immigration attorney closer to the employee's work location to aid FDNS process, or should this not matter much? What do you have to say?
So typically the FDNS stuff is not done in person. The only time it's done in person is when they, knock on your door, at your home, like on a weekend morning, and try and talk with you. And at that point, it really doesn't matter where your attorney is located at. They're not going to be at your home, and it's going to be up to you to use your wits to remember that you have a lawyer and to tell them to, contact your lawyer if they want to talk to you. So most of these things, though, are done via email or done through a phone call, or sometimes even Zoom. So I don't think it really matters so much where they're at, but it matters that you have a relationship ahead of time so that you know what to expect when they do come knocking on your door on Saturday morning, before, you fed the kids and really gotten ready for your day, so that you don't get shocked by that and stumble and do something you'll regret later.
Absolutely. And like they say, precaution is better than cure. So make sure that you take it in time. Okay, John, coming back to the case and coming back to H-1Bs, I would also like to know that what steps can, the H-1B beneficiaries take if they suspect that their employer is maybe doing some fraudulent registration practices?
So, again, the way they've restructured the registration system, it's probably not a huge concern anymore. If they feel like something is just off with the employer, if they feel that something's a little fishy, don't work with them. Find somewhere else. Go find a new employer, because it's not worth it. Because USCIS always is punishing the employee. They almost never take action against the employer, and most times they'll punish the employee for things the employer did. So that if you don't have a good feeling about what your employer is doing, trust your feelings, go somewhere else.
But then why is that? Why are they always after the employee and not the employer? Is it because they
It's
don't
easy.
have money? I mean, the employer doesn't have.
It's easier. Yeah, it's easier. In the law, there's really nothing that gives them the ability to, wholesale sanction an employer legally. they're kind of doing that under the table a little bit. But the only way that they can really impact things is through adjudication of non-immigrant petitions. And so those petitions affect obviously the employee. And that has always been their approach, is that they'll punish the employee through the petition decision, but ironically, they won't let the employee represent themselves in the petition process on any of these issues that are impacting them. And so that's why I say, if you don't have a good feeling about your employer, you know, it's best to look elsewhere.
Okay, okay. And John, also, I mean, do you anticipate further legal challenges related to the H-1B registration practices?
I don't think so. I think with the new system in place, I don't think anybody's really got a reason to challenge. I don't think it's really going to be something that people are motivated to fight.
Okay. John, thank you so much for answering the question. I also would like to discuss, Elon Musk's immigration status scrutiny. So, I mean, there were reports which surfaced suggesting that Elon may have worked in the US without proper authorization during the 1990s. So, if this is proven, this could lead to a revocation of his US citizenship, right? And maybe some potential criminal charges too. So, I would like to know from you that what are the potential legal ramifications for individuals found to have worked without proper authorization in the US?
So you're right. In theory, there is denaturalization. And if if you were found to have achieved your green card, you know, in an illegal manner, then you can't have legally naturalized. And so they kind of trace it back that way. So if any of these things were found to have shown him ineligible for a green card, in theory, he would be, rem- denaturalized in an unbiased and impartial process. But, obviously, Elon Musk is allowed to play by different rules by Trump. Elon Musk can wear a T-shirt to the White House in a cabinet meeting. But Zelensky can't wear his sweater to the Oval Office because that's disrespectful. So I I don't see Trump ever holding anybody responsible that's in his inner circle, because corruption works that way.
Right. But then also, I mean, taking such steps and doing such things, can it also ban you completely from entering the US?
So once you have your citizenship, they have to go through the denaturalization process. But if you have unauthorized employment, that does lead to 3-year bars and 10-year bars, depending on how long you worked without authorization. So that could impact whether or not somebody legally acquired their green card status.
Okay, okay. And about, the case that we discussed, the Elon Musk case. I mean, John, how do you think, such high profile cases, how do they influence people's and, public's perception and enforcement of immigration laws?
So I think it's pretty clear that there's two different sets of rules in Trump's mind, at least, and Stephen Miller's mind. There's the rule for white people in European countries, and there's the rule for everybody else. And you see that in their policy and the way they enforce. So I think that's, as long as we have Trump and Stephen Miller in play, that's what we're going to have to be looking forward to, and taking extra steps to protect yourself, because they're trying to create an uneven playing field.
Okay. All right. Okay. I think I was just about to, wrap up, but then we have got another question for you, John. V2 is here and says, I am on an H-1B visa and recently filed AOS. I-485, I-131, I-765. My I-765 is approved, but I-485 and I-131 are pending. Do I receive the EAD card or just the I-797A approval notice?
You
And
should
yes, please go ahead. Okay, I think, guys, there is some technical error or maybe a glitch. Okay, I think John is back.
Rajni?
Yeah, I can hear you, John. Please go ahead. John, can you hear me? Hello, guys. I think there is some technical error. We can see John very clearly, but we can't hear him. I mean, we can hear him, but he can't hear us. So maybe John, can you hear us now? Okay, maybe we can try to reconnect. Okay, we are going to fix this issue, and John is going to be back soon. And we too, please stay here, and he will be answering your question. And yes, we are going to fix this issue very quickly. Let's go take a short break until then. And yes, we'll be back right away. You don't go anywhere. Thank you so much for waiting so patiently, guys. Welcome back to Immigration Talk Show, and I hope that the problem is fixed. John, welcome back. I hope the
Thank
problem is
you.
fixed.
Yeah, I hope so too.
Okay, so our viewers were waiting patiently to get an answer from you. So if you can please help V2 with an answer.
So you should receive the EAD card. Normally it's done as a combo card with the EAD and 131. So they could be waiting to adjudicate the 131 before sending out that card.
Okay, and he goes on to say that can I use I-797A for I-9, and is it advisable to switch to the CO9 EAD?
So you need the actual EAD card in order to work on it. So I would wait for that before switching over.
Okay. Um,
But
he-
I would say also, Justin Rivera in our firm, he deals with these types of issues. I deal with the litigation, but it's probably worth just giving Justin a call just to, you know, double check and make sure you're doing everything correctly.
Yes, we have regular webinars with Justin here too. I'm sure our viewers already know him. So, guys, you can also give Justin a call. This is John's number. If you can also display Justin's number. Okay, so this is Justin's number. You can give him a call on the number 844-592-7336. Again, and you can also email them. John and Justin both will be available and they'll be able to help you with your case. You can email them on the email ID support@wasden.law, and you can also visit the website to get more info about the team, www.wasden.law. And John, V2 is back and he says, I'm on an H-1B visa, married to a US citizen, and recently filed, I think, same question. Thanks a lot. Okay, I think he got his answer. Okay. Okay, so I think we should wrap it up for today because we are going to do another webinar on this where you are going to take everything and all these questions, and you're going to discuss this policy and fraud findings in detail. So guys, make sure that you are tuned in that webinar. So stay tuned with Immigration Talk Show. Follow us, subscribe to us. Yes, and John is soon going to come up with another detailed webinar on DHS's policy and fraud findings. So thank you so much, John, for being here. It was a great episode, and I hope you enjoyed it too.
Thank you. It was a great time.
Thank you so much. And to our lovely viewers, thank you so much for all your questions. We, like I said, I'm continuously repeating, so I would like to repeat it one more time that we are again going to come up with another webinar on the same topic. It is going to be a detailed one, so make sure that you are, uh, in sync with all the details and with each and every information regarding that webinar. We are going to post all the details and all the time, the date, and the day of the webinar very soon in all our platforms. So make sure that you follow us, subscribe to us, and okay, so Rag is again already excited and says, can't wait for the next with John and Rajni. Thank you so much, Rag, for your comment. And yes, I am hoping to see you all very soon. But for now, I'll have to take your leave. And thank you so much for being here. It was lovely chatting with all of you and taking your questions. But for now, I'll have to take your leave and seeing you. I hope to see you all very soon. Bye. Take care and keep on watching Immigration Talk Show.